Ms. Platt, for the President.
There are nuances and differences attaching to each. I will then make submissions with regards to those ones individually. Yes, my Lord.
Are you opposing all the intervention applications?
I'm opposing all the intervention applications. I will make one submission with regards to all of them, and where there are nuances and differences with relation to each of them, I will just touch on that.
Perhaps before you start, in order not to break your flow,
Yes, my Lord.
what do you say about the court order of the 14th of October?
The court order of the 14th of October was not a consolidation application. My Lord, when I appeared, I stood up and said that I was here for the second respondent, and I was not sure why I was here because I haven't been served with any papers. And that was the submission made on behalf of the applicant, which is the President. We were told we are a second respondent. Then they said intervening parties can then file papers on the Monday. We agreed to that. And we have expected a proper joinder application with regards to the EFF and UDM and COPE. Just like the DA did. The DA intervened in both case numbers. It intervened in our case as well as intervened in the Van Rooyen, as my learned colleague Mr. Mpofu says, Van Rooyen 1. So the DA intervened in both. Ms. Mentor intervened in this one. Yes, my Lord.
You, and every time I say you, please, I'm referring to applying the President.
Yes, my Lord.
Did you not agree to the applications being had together?
I agree that the applications should be heard together. Yes, my Lord.
So it is the formal consolidation you're opposing?
Well, there was no formal consolidation.
Well, they seek it now.
They seek, my Lord, there's no formal papers before you. They raise in a replying affidavit a joinder. But, my Lord, we're not going on the consolidation. If my Lord feels that there is a consolidation, we're not going there. Our opposition is not directed solely on consolidation and joinder. Our opposition is based on direct and substantial interest. And that's the point we're going on. That's the point we're relying on, not on the Section 38 joinder, consolidation, any of those points. If we fail on direct and substantial interest, we will fail on any of the other ones. My Lord,
You may continue, Adv Platt.
yes. My Lord, this is an application in where the President has come to enforce procedural rights. That procedural rights attaches to the President and the President only. Those procedural rights do not attach to the public, nor do they attach to the political parties or to any intervening party. And those procedural rights and the processes followed therein has been admitted by the respondent. So the applicant brought an application against the respondents, which is the public protector, to enforce procedural rights. My Lord, and if I could take you to page 83 of the main application, which is the respondent's affidavit.
What page? 83?
Page 83 of the main application bundle, paragraph 6.7.1. It says the facts 7.1. It says the facts concerning the process followed by Advocate Madonsela in preparing the report are essentially as set out in the affidavit of the President at paragraphs 13 to 27 of his founding affidavit, excluding paragraph 21, which amounts to comment on the facts. To the extent that those paragraphs annex and set out the correspondence between Advocate Madonsela and the President, they appear to be accurate and constitute the common cause facts on which the President's application falls to be decided. That is what the Public Protector has said, that the common cause facts on which the President's application is made has been agreed to. They are common cause between the applicant and the respondent, because these are procedural rights that can only attach to the respondent. To the applicant. It's the applicant that is being an implicated person. It is the applicant that's being asked to answer questions. It is the applicant that was given the right to pose questions to witnesses by the Public Protector, in which she says she will determine the process in terms of the Act as to how those questions can be posed and to who. So the Public Protector has admitted all those facts. Those facts cannot be refuted by any of the intervening parties, because they...
I just want to understand.
Yes, ma'am.
Do you submit that the procedural rights which you say attached to the President alone
Yes.
should be looked at in isolation, excluding the rights of any other person?
Because this is what the application is based on.
But is that your submission?
Yes, and I'll explain why I say that later. So the only two parties that are aware of the procedural requirements are the applicant and the respondents. And both have made common cause amongst each other on the facts. So there's no party that can refute those facts. They attempt to do so, but they cannot refute it because they say they don't know the process or they don't know the questions. So on that basis, we say that because there are procedural requirements that needed to be followed, which has been admitted by the respondents, that relief attaches to the President only. Now, with direct and substantial interest, can I just quote from, sorry. I'm sorry, this is just doing something. Sorry, my lord, we're just trying to... It's Gordon versus Department of Health, 2009, 1, All South Africa, 39, SCA at paragraph 9. And the Supreme Court of Appeal stated the following: the issue in our matter, as it is in any non-joinder dispute, is whether the party sought to be joined has a direct and substantial interest in the matter. The test is whether a party that is alleged to be a necessary party has a legal interest in the subject matter, which may be affected prejudicially by the judgment of the court in the proceedings concerned. In the Amalgamated Engineering Union case Supra, it was found that the question of joinder should not depend on the nature of the subject matter, but on the manner in which and the extent to which the court's order may affect the interests of third parties. The court formulated the approach as first to consider whether the third party would have locus standi to claim relief concerning the same subject matter, and then to examine whether a situation could arise in which, because the third party had not been joined, any order the court might make would not be res judicata against him, entitling him to approach the court again concerning the same subject matter and possibly obtain an order irreconcilable with the order made in the first instance. And we say that the intervening parties do not have a right to intervene on that basis, because in order to state that procedural requirements as attaching to the President was not followed does not affect their right to know what is in the report. Because if that order was given, it is not irreconcilable with any other order that they could attain. Because once those procedural requirements have been met and the report released, they have every right to look at that report and deal with it on that basis. We're saying that procedural requirements as attaching to the President cannot be a direct and substantial interest, because they cannot say that their interest to know has been affected by the President obtaining an order that he has the right to answer questions. They cannot say that that is a direct and substantial interest. They cannot say that he has a right to ask questions, that it will affect their rights to know. Because ultimately, once those procedural requirements have been fulfilled and a report issued, they can then challenge that report as to whether there is any other basis for why they have a difficulty with it. If that is the case, it doesn't affect the order that the President seeks. And that order is merely, give me an opportunity to exercise my rights, as you say I have. As you've said to me, I look forward to your questions, Mr. President, in relation to the witnesses, and I will determine how that procedure will follow. The Public Protector has said that, and then promptly thereafter finalizes a report. We are saying procedural requirements were not followed. The Public Protector has agreed with that, and it's on that basis that we say any order here will not have a direct and substantial interest on any of the intervening parties. My Lord, and then we will not go to Section 38. I just want to check that I've covered everything. So the direct and substantial interest will go through to all parties. The submissions made by UDM and COPE with regards to impeachment, that happens in a different format. No order here will affect impeachment proceedings. Those happen in Parliament and not in front of this court. So what is in the report and its outcomes will not affect the political parties if the President is given a right to fulfill its procedural requirements that the Public Protector has agreed he has. With regard to Ms. Mentor's application with reference to cross-examination, we do concede that it's not a cross-examination. However, we are entitled to pose questions as determined by the Public Protector in terms of the Act. And we're saying on that basis, we are allowed to ask questions. And it's the Public Protector that will determine how those questions will be posed and in what format and whether she will be posing those questions. Because the letter reads, and if I can just take you to that letter, it's Annexure K, my Lord, page 72 to 76. It's paragraph 11, page 75, my Lord. This is on the 11th of October, 2016. And she says, I look forward to receiving the questions you wish to pose to witnesses who have appeared before me. I shall make a determination on such questions in accordance with the Public Protector Act, creating a legitimate expectation by the President that he would be allowed to ask those questions. That has not been denied. Yes. The Public Protector gave the legitimate expectation to the President, that he would be able to ask questions and she would determine how that would happen. And that is correct, because that's what Section 7(9) of the Public Protector Act says. So we say on that basis, that Ms. Mentor does not have a direct and substantial interest in the matter. And as a witness, we say that in the Harams decision of the Supreme Court of Appeal, in the National Director of Public Prosecutions versus Zuma, 2009, 2 SA 277 SCA, at paragraph 85, it says, I'll read from 84, just to give context. In this matter, Mr. President Mbeki, as he then was, sought to intervene in an application in the appeal. And the court says, nevertheless, to be able to intervene in proceedings, a party must have a direct and substantial interest in the outcome of the litigation, whether in the court of first instance or on appeal. The basic problem with the application is that the applicants have no interest in the order, but only in the reasoning. They are in the position of a witness whose evidence has been rejected or on whose demeanour an unfavourable finding has been expressed. Such a person has no ready remedy, especially not by means of intervention. And that is Mrs. Mentor's entire case, that she gave evidence, she is a witness, and therefore she needs to intervene. And we're saying, according to the SCA, you do not have a right and a ready remedy to intervene in an application of this nature. My Lord, and she also states, Ms. Mentor, in paragraph 49, page 17 of her intervention application. It's paragraph 14.
Paginated 17.
Page 17, paragraph 49 of Ms. Mentor's application. She says, indeed, had I known that as a consequence of my disclosures, I would have been at risk of being cross-examined directly by the President or his or her legal representatives, I would have been far more circumspect about making the disclosures in the first place. Thus, if the President's interpretation of Section 792 were to be adopted, it would hamper the public protector's ability to combat corruption. And we say this can never be the case, because as the Constitutional Court has said, the public protector's findings are binding. So therefore, the proper procedural requirements need to be followed in order for that binding finding to be made. And for a witness to say that they would have been far more circumspect in making their disclosures is very worrying, my Lord. My Lord, so that is the basis of which we oppose the applications, that they do not have a direct and substantial interest on purely procedural requirements on which all of the parties have no direct facts to rebut what the public protector has said. As it is.
Thank you, Advocate Platt.